Another ruling handed down by the High Court this week dealt with the Baby Veronica case. The lawsuit between an adoptive couple and Veronica's Cherokee father was sent back to the lower courts. But up until that point, the case hinged on a little-known act, the Indian Child Welfare Act. ONR's Dick Pryor spoke with Native American law professor Taiawagi Helton about the case and the law that made it possible.
Professor Helton, what is the purpose of the Indian Child Welfare Act?
The Indian Child Welfare Act was passed in 1978, and it was intended primarily to do two things. First, to undo the harm of prior federal policies, and then secondly, to set minimum federal standards when state court proceedings are addressing the placement of an Indian child, to make sure that the state courts consider to set minimum federal standards for the placement of children or the removal of children from their homes, so that the courts would consider the essential Indian relations and the protection of culture. And the statute clearly says that it's intended to protect the best interests of Indian children and to protect Indian families and communities. So it wasn't aimed only at protecting a child, but aimed at protecting families and communities as well.
This is very complicated. What are the legal issues in the Baby Veronica case?
In this case, the biological father was a member of the Cherokee Nation. He was unmarried to a non-native, to the non-native mother, and although they talked about getting married prior to Baby Veronica being born, the mother decided not to get married. And I understand that about 6 days before the father shipped out to Iraq, he received papers asking him to waive his parental rights. And he describes himself as doing so because he thought it might be a sign of good faith that he might be able to reconcile with the mother later on. And that ends up being an issue because the court focuses on that fact in part to come to the conclusion that it does. But the statute has certain protections in it. So in section 1912F, the statute says that before before the parental rights can be terminated, there has to be a showing beyond a reasonable doubt that the continued custody of the child would likely result in serious emotional or physical harm. And the court said that that provision doesn't apply at all because in this case, the father never had custody. And so there was no continued custody to consider, and they emphasized that the primary purpose is to protect or prevent the breakup of Indian families. And here, because the father never had custody, the adoptive couple were at the birth and took custody of the child immediately, they said that section doesn't apply. The second section, 1912D, says before you can involuntarily terminate parental rights of a tribal member, you have to make a showing that the state made efforts to provide rehabilitation or some sort of relief in order to prevent the breakup of the family before being able to terminate those rights. And the court said, in this, it was a 5-4 decision, and Justice Alito's majority decision, the court said that there was no relationship to dissolve because the father had abandoned the baby when she was an infant, and so there was no family to break up.
What does the Supreme Court decision mean?
The decision has been described as being a narrow ruling, and it is compared to an expansive constitutional one. There were some folks who thought that the Supreme Court might declare the statute unconstitutional in its entirety on the basis of racial distinction. And so many people say that the statute has been upheld and that this is narrowly applied. But I actually think that it's more troubling than that. The Supreme Court decision, I think, harms non-custodial Native fathers relative to Native mothers, for example, and I think they have so narrowly construed the purpose of the statute, which is more broadly stated than the court suggests, that they've limited its application. And I think they've effectively created or resurrected what was once described as the existing Indian family exception that was created by some state courts that have since abandoned it for the most part. I think there are about 5 states that still do, but I think the court has narrowly construed it to only prevent the breakup of families, and now they assert that you've got to have a family in its existence before being broken up.
And now it goes back to the lower court.
And it goes back to the state courts of South Carolina.
Professor Taiawagi Helton, thank you very much for joining us.
I was pleased to do so. Thanks for having me.